indigenous sisters and brothers. I, on behalf of Kappaeeng Foundation, a national human rights organization of indigenous peoples, and Bangladesh Indigenous Peoples Forum, National Platform of Indigenous Peoples, congratulate Mr. Lars Anders Beyer, the special reporter, for his authentic and excellent report on the study on the status of implementation of the CHD Accord of 1997. Though the government of Bangladesh signed the Chittagong Hilltrucks Accord with the indigenous political party PCJSS in 1997 and implemented few provisions of the accord, but as Mr. Lars Anders Beyer says, 13 years have passed since the signing of the CHD Accord, yet many of its provisions remain unimplemented. Due to non-implementation of the CHD Accord, indigenous Jumma women are deprived of their basic rights, including representation of indigenous Jumma women to 3 Hill District Councils. The CHD Accord has provided reserved seats for women and indigenous women in both CHD Regional Council and Hill District Councils, but the provisions still remain to be implemented due to non-holding of election to the Hill District Councils in the post-Accord period. Consequently, it has deprived indigenous Jumma women of their rightful participation in these councils. Interim Hill District Councils continue to be formed only by nomination from the ruling party. As a result, Hill District Councils function without any accountability to the people. Due to non-resolution of land disputes, Bengali settlers enjoy impunity to grab indigenous lands with support from a section of civil and military administrations. Indigenous women often fell victim to this land grabbing spree. Continuation of de facto military role, codenamed Operation Uttaran in Chittagong Hilltrucks, contributes to gross human rights violation on indigenous peoples, including sexual violence against Jumma women. For the sake of security and safety of indigenous Jumma women, withdrawal of all temporary army camps, and immediate resolution of land disputes, rehabilitation of Bengali settlers outside Chittagong Hilltrucks as required by 1997 Accord, effective functioning of special governance system are the call of the hour. It is worth mentioning that government of Bangladesh frequently says, has just been said again, Bangladesh doesn't have any indigenous population. Co-chairman of Special Parliamentary Committee for Constitution Amendment, Mr. Surunjit Sengupta, also says demand for constitutional recognition as indigenous peoples could not be applicable in the context of Bangladesh. However, the legal situation is quite different. The Chittagong Hilltrucks regulation of 1900 uses both terms indigenous tribe and indigenous hillman interchangeably. A 1995 law, primarily a finance law, but also containing specific references to the exemption of income tax payments by indigenous peoples in CHD, uses the term indigenous hillman. Furthermore, in a recent case in the High Court Division of the Supreme Court of Bangladesh, the court took cognizance of the fact that the petitioner was an indigenous hillman of the CHD. The East Bengal State Acquisition and Tenancy Act of 1950 uses the phrase Aboriginal tribes to refer to several groups living in the plain regions who now identify themselves as indigenous peoples. The Honorable First Secretary of Bangladesh Mission, Mr. Ahmed, has repeatedly said that we are not indigenous people. He says we are tribals and ethnic minority. As an indigenous person from Chittagong Hilltrucks and representing indigenous people, we reject this position. We reject this position as tribal. We are indigenous people and we must be recognized as such by our government. Thank you, Madam Chair.